exempted out of Child Protective Services investigation, et cetera. So is that your understanding as well?
Yeah, I have a different understanding, but I will actually defer to the next panel to perhaps with the three attorneys to address that question. My read of the law is that there currently is there's a reporting up, not reporting out requirement. And I think Dean Gels had alluded to that in terms of some of the...
And I probably should have addressed that with him as well, but I see that he did have to leave us. I was hoping that perhaps when I ask you this question, he would still be here.
Bob Schwartz can answer that for you. I trust him.
He could.
I'll defer to my colleague to answer that.
Thank you very much.
Okay, you're welcome.
I have one comment for the record, and that's that this problem with not identifying a perpetrator is not really only for sexual abuse cases. Rachel and I will tell you that in some of the most severe physical abuse cases, because there have been multiple caregivers to that child, they can't always identify the perpetrator. So that's just another issue.
Thank you.
Yes, thank you, first of all, for being a very good report and being very specific with your recommendations. Is something I really can look at, and I have a couple of comments and maybe a question. The Dean referred earlier, it's just good operating procedure, to have internally some type of procedure for your employees, and being in charge of a fairly large facility, we do. But you very specifically are saying that should be included into the law.
Yes.
Okay. And I don't have a problem with
I would say just because if you have good best practice doesn't mean other folks do.
Right. The other thing, just a comment about when you have the differential response, you have the findings, which are very helpful, in making decisions going down the road, because it's been my belief that good training is at the key of all this. And, of course, we have limited resources, and we heard we have to be efficient with the resources we have. Quickly, at a Girl Scout meeting, I went to a 911 response center. I got an education because they don't assign the call that said the cat's up the tree to just anyone. That's the new person on the block. The skilled people who have the best training get the most difficult assignments. And I think out of my experience, and that again is operational in our organization, in our state, we have to take a look at how do we respond and who responds to it, the best people. Because there are hours and hours and dollars that are wasted on fire drills that could be done differently. You spoke, so I appreciate these specific findings that you have there, and I'd like to talk to you a little bit about those later. Someone mentioned a failure not increasing. You do not believe you should increase the penalty for failing to report. Have you had any response, or do you have any response to reports that would be knowingly false or maliciously false?
Yeah, I mean, absolutely, and I think that's, that is in most reporting statutes that there should be sanctions for that. One of the things, for example, is cases in custody battles, and we saw that, as an investigator, you're nodding your head, it's the bane of every CPS investigator's existence when one parent alleges that another parent is sexually abusing their child, and lo and behold, they're involved in a custody battle. One of the things that we found through the differential response system is those reports started going away when people saw they weren't going to get an investigation. When it was going to be referred for services, you think that's going on? Wonderful, we'll provide your family services. No, I want you to substantiate that so I can go to court and win custody of my child. When that wasn't one of the possible outcomes, those reports started going down. So, I think in terms of addressing that's critical. We can't afford to bog down the system.
Thank you.
I'm going to pass.
And for the record, Judge Grimm has joined us near the beginning of your testimony.
I just want to state that in my 24 years as a judge, I have probably heard hundreds of times, "I'm sorry I'm late, Your Honor. I had car trouble." "I'm sorry I'm late, Mr. Chair. I had car trouble." I'm very intrigued by your experience in Arizona with the Family Builders differential response, and I've found in my own experience that a private and public sector collaborative effort can be extraordinarily effective. One of the areas that I've found challenges and opportunities is in the area of making sure that these services as offered are culturally sensitive. And I'm wondering if you could address that with regard to whether you found that difficult to do, whether it was cost-effective, and whether you agree that it is important that those services be culturally sensitive.
Yeah, thank you for asking that question, because that's a question it's often ignored. Working in Arizona, Tucson, which is an hour north of the Mexican border, that was a critical issue. And our agency not only had a commitment to provide services to families in their language, we chose not to use interpreters because we felt that that was really not the best way to do things. So we assured that our staff reflected the cultural diversity of the community that they served, and we had culturally competent workers. One of the things that one of our lessons that we learned is also to be sensitive to subcultures within culture. I learned when I had a therapist from Puerto Rico that the language that she used was not the same language that families used who were from a certain section of Mexico, and they had different interpretations of words, and we actually had some kind of comical experiences with her saying something and the family hearing something else. So it's important to drive it down to really to the community level. Who is in your community? And address that. One of the blessings, and you were talking about the opportunities, is how we form these collaborations. And what we did was we gathered together who we thought, and we were the lead agency, were the best people who delivered services in the community, and gathered them at the table. And then among us decided, okay, we had a list of services we were required to provide. There were about 12 or so different services that were mandated. And some of us, many agencies provided the same service. So among us, we really took a hard look and said, okay, who's best at this out of all of us? Who's the best agency that does home-based therapy? Okay, you will do the home-based therapy, but you're really good with your drug treatment program is second to none. And by forming collaborations and giving the responsibility to the community, obviously with oversight, the cream rises to the top, and you're really able to get the best out of your community and have the community understand who the families are that live there and be best responsive. I think Dean Gellis brought out a very good point earlier that unfortunately you didn't hear, one of the many good points. It's troublesome when we look that services are not available in the communities in which families live, that we bring services from outside the community into where they are. Services are so much more meaningful if they are part of the community. You want families, when the state is done working with them, to have resources so they can help care for themselves. And if you're not sensitive to the local culture and the local community, you're not going to establish those longer-term safety nets. So it's kind of a long response to your question.
No, very good. Thank you.
Mr. Chair, just can I ask that you just take one question? It's probably a big one, and think about it maybe with Dean Gellis, and you give us a response or me a response. I'm hearing what you're saying about the way other states have done it with all these cases being essentially CPS from the onset. In order for us to make that happen in Pennsylvania, I've been thinking about this a long time. There are really two statutory animals that we work with in Pennsylvania, the Juvenile Act and the CPSL. The Juvenile Act's a two-headed animal dealing with delinquency and dependency. And if we're talking about a decade worth of rewriting necessary for the CPSL, would it be wise to consider essentially severing off the dependency aspect of the Juvenile Act and merging it into a rewrite of the CPSL? So I just ask you to take that with you.
I will take that back, and I'll take that back to particularly the legal folks on our team who can probably think of that. Well, it's an interesting question.
All right. Thank you very, very much. You've given us some wonderful concrete suggestions. I think it is fair to say that the University of Pennsylvania and the Field Center will have its imprint on what we ultimately do as a commission or task force or whatever the heck we are. And we will continue to march right ahead, and We have, although I see that the materials before us do not recognize Mr. Schwartz. I guess Mr. Schwartz has been out of the Philadelphia DA's office for...
Juvenile Law Center.
Juvenile law center.
Bob is Juvenile Law Center.
But you were once?
No.
Never?
Yeah, my friends in the DA's office will confirm that.
But they were.
Gee.
I like to take different precedents.
Those two were.
No, he just doesn't do that.
Well, then how the heck did I get to know you?
We got to know each other through PCCD.
Okay.
Okay. You guys
Okay.
don't want bathroom breaks, huh?
Okay. Well, we have then Robert Schwartz, who I thought was once long ago in the Philadelphia District Attorney's Office concerning himself with, certainly has done remarkable work for many years for the juveniles, young people of our Commonwealth. Leslie Gomez, now with Ballard Spahr, formerly with the Philadelphia District Attorney's Office, and Gina Maisto-Smith, also with Ballard Spahr, formerly with the Philadelphia District Attorney's Office. And you folks seem to have taken your seats and are ready to go. Whoever wants to start first.
I just want to make sure nobody needs a break before you start. You guys.
I can't speak for the audience, but I think we're okay.
Yeah.
Okay, good.
And I think we always run into this problem. We have wonderful, fully packed programs, and the members of the panel either have developed hardy capacities or will just slip off as they need to.
Okay, thank you very much, Chairman Heckler and members of the task force. I'm going to do a mix of departure and reading from the testimony that you have there, in part to respond to some of the really excellent testimony that you've already heard. And I thought they were just superb witnesses for you. And to have a little disclaimer at the outset that we at Juvenile Law Center have not been working in the child protection area intensely in recent years, although it was a core part of our early work. So the reason that I'm here, I think, is because I'm old and was around at the time when the CPSL was passed and can bring some institutional memory to what's been happening over the last 37 years. So the Juvenile Law Center opened its doors in 1975, and a few months later, the Child Protective Services Law was passed. And much of my work over the following couple of decades was involved in representing children who were abused, neglected in Philadelphia and other courts around the Commonwealth. I would just mention, just to clarify again, that there are three vehicles for protecting children. The Child Protective Services Law is one of them. It's the vehicle that addresses the reporting of kids most at risk and the investigation of them, and I'll get into that in a second. And then, as Mr. Koudalakis mentioned, there's the Juvenile Act. That's the framework for the service delivery system and how the system operates once a child is brought into the system for state attention. And then there's also the law enforcement approach to child protection, which you will also hear about on this panel. So there are three different approaches in law, and they have three different purposes and vehicles. So this morning I want to touch on three overlapping areas. One is the brief history of the CPSL, which, as you've already heard, is in many ways an incoherent law today and confuses much more than it clarifies. Touch, as others before me have, on what I think of as the paradox of child protection, that the more things you call child abuse and the more reporters you have, the fewer children you end up protecting, and the importance of simplicity and concreteness in legislation like this so that even the lawyers can understand what the law says. I think that would be helpful. So let me mention, in our 2 years after we opened our doors, we published the first edition of Child Abuse in the Law. That was 1977. And we've published 7 editions since then, and I've been scouring the office. We have 3 or 4 left, and you'll become custodian of one of them before I leave. It's also on our website, so it's pretty easy to download. And one reason we've published 7 editions is that there have been significant changes layered on. And it's not as though the changes have been made with replacing some things and finding the best way of answering the questions you've been asking today. It's been layering on changes every 4 or 5 years to respond to the latest crisis, and that's created the composite statute that we have today. In the beginning, in 1975, the CPSL had fairly limited goals, and those goals, they weren't designed to protect all children from all harms. There are other vehicles, including county children and youth agencies and other community resources that can do that. The greatest debate in 1975 was whether poverty would be considered child abuse. That's what caused the delay in passing the law. Philadelphia Welfare Rights Organization and many other advocates across the state got included in the law the section that I mentioned in my testimony, that no child shall be deemed to be physically or mentally abused based solely from environmental factors beyond the control of the parent. Once that debate was resolved, the law was passed and became effective in the fall of 1975. And the CPSL had several limited vehicles for child protection. One was by defining child abuse as involving serious physical abuse, neglect, or serious neglect or sexual abuse, so that there would be a category of problems that children were having and risk of harm to children that would trigger a quick response by the system. Mandating reporting to make sure that those serious cases got to the attention of the system, and requiring immediate county investigations for the cases where the kids were most at risk of harm, and finally creating a registry so that abusers couldn't move from county to county or state to state and escape detection in ways that had happened prior to that. I think this was a law certainly passed in the wake of the Child Abuse Prevention and Treatment Act, the Federal Act. What I don't get into here, and others may or may not have addressed before you, is that Pennsylvania hadn't come into compliance with CAPTA until a few years ago anyway, because of our definition requiring serious neglect and the small amount of money that CAPTA provides to the state wasn't much of a lever in getting the state to come into compliance. But we did, like every other state, enact a Child Protective Services law. It was aimed originally primarily at parental abuse of children, and by, say, parental abuse, that included the caretakers, relatives, custodians in the household, whether or not the abuse took place in the home or out of the home. It was not originally designed to address stranger abuse. That was basically considered a law enforcement function. So it was also never designed to replace the Juvenile Act's framework for case processing. And much of the discussion that you've heard, or a part of the discussion you've heard today on risk management and services and the kind of services that children should receive in the home or out of the home is all governed by the Juvenile Act. The CPSL has some guidance, certainly, on multidisciplinary teams and ways to try to preserve families where possible, but the basic vehicle is the Juvenile Act. And actually, to cut to the chase, actually, for your question, Jason, I like the Integrated Juvenile Act very well. I think it's actually one of the best statutes in the country for enabling judges in both systems to have access to a wide array of services that are available to all children. And I think when I travel around the country, folks are stunned that delinquent court judges can order services for dependent children, that the movement between dependency and delinquency is a little more fluid than it is in many other states, and that the Department of Public Welfare has the authority to regulate and license both, and to do that in a meaningful way. And we can certainly get into that more. But the Juvenile Act was not written to trigger the investigation that the CPSL does, or the mandatory reporting or the definition of perpetrator. Child abuse is a subset of the definition of dependent children. There are 10 definitions of dependent children. The word abuse never even appears among those definitions. It's in the first definition of a kid who is without adequate parental care and control necessary for their well-being, blah, blah, blah. But it's the CPSL has its place. The amendments of the last 35 years have generally required the child protection piece of the Child Welfare Agency to do more and more and more. They've increased, and they've also made changes that have been perplexing even to us lawyers. As you say, well, reason to suspect is much different than reason to believe, and then some people say, well, I don't know, which is which, which really protects children more. You spend time figuring that out, and children are sitting here while we're trying to decide whether we're suspecting or believing, and it really never has done kids a whole lot of good. So the same with the issue of GPS. GPS was originally a part of the Public Welfare Code, or the Code of Regulations that DPW promulgated, and it was an effort to sort of fill in the gaps between the cases that weren't investigated immediately and the cases that needed to be attended to pretty quickly but couldn't take too much delay. And that was in a part of the regulatory framework that gave DPW some flexibility in making changes, and the legislature, in its wisdom, in the early 90s decided, let's move it from regulations where it can be changed and fixed and helpful to a statute where it will sit forever inert and incomprehensible to folks. So we have that add-on. When there was abuse in schools, we took abuse by school officials from a law enforcement responsibility and made it a joint responsibility that now added more work to the child protection system that, again, as you've heard, doesn't necessarily help children. So, and I would also just say that one of the things that was added over 20 years ago now was a requirement that every county use risk assessment tools that are approved by the Department of Public Welfare. That is in the Child Protective Services law. The structured decision-making that you heard about from Dean Gellis has actually been a requirement of the statute in Pennsylvania for over 20 years. And in the early 90s, the Department of Public Welfare approved 3 risk assessment tools that weren't sort of automatic decision makers. They could be overridden, and Dean Gellis gave you examples of how, that you make your decision and then justify it later through the risk assessment tool. But the risk assessment tool, like the issue of whether a case is substantiated or not, the risk assessment tool is something that happened after a case was investigated and not something to decide whether a case fits the definition of child abuse or whether this kid should join the registry. It was about service delivery. So, there are a couple of things that have happened. One is that many counties just stopped using risk assessment tools. So in Philadelphia, for example, during one of the many Blue Ribbon Commission recommendations, of the one of the last 2 decades, we've had, a bunch of them, folks around 2005, I think Arthur Evans, when he was the acting commissioner, said, geez, we ought to have risk assessment tools. We've had risk assessment tools, or we used to have risk assessment tools, and some of them work quite effectively. So it's always puzzled me as an outsider, wondering about the ebbs and flows of fidelity to things that are in the statute. You've heard about the issue of adding more and more work to child protection agencies and the problem that causes in actually protecting children. And I just want to reinforce that and to suggest something, a way for you to think about the work that you do with respect to mandatory reporting, reporters, and investigation. And that's not to think of a single case and how it's processed. In my testimony, I talk about legislators, including those who imagined the Adoption Assistance and Child Welfare Act of 1980, ASFA when it was passed in 1997, the Adoption and Safe Families Act, and other legislation relating to children. We always have an image of a kid coming in. There's a call. As I say, there's a well-trained, experienced worker who takes the call, has an unlimited amount of time, has access to risk management tools. They get the facts, make a decision, use the risk assessment tool in a structured way, decides how to link the kid and the family to services, and there's an ongoing thoughtful monitoring of the case. And of course, that's not what happens, right? So the trick is to imagine thousands of cases and how they're going to be handled, and to imagine the implementation of a system that has thousands of cases that protects the kids most at risk of harm in the first instance. And I think that some of the suggestions that have been made here are good ones. I don't address in my testimony the issue of severe pain in the definition, but I think that's absolutely right. And there are other suggestions that I make in my testimony. Well, we can't call all things child abuse. You know, it's the example I use here is the student who, with using a highlighter, highlights everything on the page. And of course, when you highlight everything on the page, nothing is highlighted. This is what we see too often. The other thing is, I realize I wasn't going to use a football metaphor here under the circumstances, but since others have mentioned football, I will too. Sort of Andy Reid, the football coach of the Eagles, always says every time they lose, I have to put the players in a better position to succeed. Well, I think that your recommendations ought to try to do the same. And for this system to give workers a chance of success, there has to be clarity and limits, I think, concreteness, something that really will focus on the high-end cases and will raise the substantiation rate of the calls that come into the system, because those are the kids who are at highest risk, and a system that responds quickly. So I would not increase the number of people who are mandated reporters. I think that's asking for trouble. I think you do, again, should focus on kids who are at highest risk of harm and at higher risk of harm in their homes. I mean, frankly, I would get rid of the GPS piece from the CPSL. I would get rid of the whole school section, because next thing you know, you're going to be adding a church section, and before you know it, you're going to be adding a state-related university section, and it just doesn't work. We have law enforcement for that, and you have other vehicles for that. I would get rid of, in this law, imminent risk of harm, for the mandatory reporting. That was another one that was added, I think, when Michael Jackson held a child outside a window. All of a sudden we're changing our laws to require mandatory reporting of imminent risk. And again, when you exclude people from mandating, it doesn't mean that they can't. And many people do report kids who are at risk, even when they're not mandated to do so, or even if it's not part of the definition. And even if it doesn't fit the CPSL, many children enter the child welfare system and are protected by it, even if it's not part of the CPS piece of it. But we have to make some choices about how we use limited resources, and I want to see us protect the kids who are at highest risk of harm. And the final thing I'll leave you with, and turn it over to my colleagues, or however you want to operate, Mr. Chairman, since actually you're in charge, and if you want questions now, that's fine too, is that we have to do this with a little bit of humility, that large legislative schemes rarely work as those of us who design them intend them to work. There's a lot of slip between lip and cup, and there are unintended consequences that we really need to be wary of. We've seen that in every human service system that is in the risk management business, and I think that we ought to recognize our limits and give the people in a more, who do this work in a more limited way the chance to succeed at what they do, because it's too important not to. So.
One thing I would bring to your attention, I know Bob has a 1 o'clock train.
Yeah. So, yeah, and so I'm not going to eat lunch today. I want you to know that, but I do have a train to catch. Oh, thank you. That's very sweet.
Then let me just make the observation, Bob, that you are somebody who probably should look at our work after we've done a draft of it, because your final comments are very, very true. Been around the legislature some. There is nothing harder than drafting, and there is nothing more likely than you will create a host of unintended consequences, which may be almost as bad as whatever you're trying to correct.
And also look for grammar.
Well, great. That's does anyone, in view of Mr. Schwartz, need to escape? I thank you. Perhaps we could start. I forget which end we're at. Judge, you're used to grilling lawyers of Mr. Schwartz ilk.
I'm not used to.
It's even worse than you think.
I'm not used to grilling this lawyer, let me tell you. Bob, you've really answered one of the questions I have with regard to your view on mandated reporting. And while I would never disagree with you, perhaps in private, but not publicly, 17 states apparently have seen fit to broaden the scope of mandated reporter to universal reporting. And are you aware in those states, Delaware, as I understand, being the one closest to Pennsylvania geographically, of how that has worked, whether it's caused any unique problems for them that we ought to be aware of?
No, I really don't know. I really don't. But I think the field center could probably give you answers to that.
Okay. Thank you.
The button on. Mr. Schwartz, thank you very much. You stopped just short of the sentence I was waiting for you to speak to, the abuse in schools and institutions, that they be eliminated from CPS and be investigated by law. That's interesting. Okay.
Attorney Schwartz, thank you, and I appreciate your sense of humor about the subject. It is a dark subject that we have to, but
I don't want the parents to say that I'm joking about childhood.
No. But I think it's clear that your recommendation is to simplify, right? So you talk about eliminating certain definitions. How would you envision it looking then? If we were to eliminate those definitions, which would actually be what I would think would be helpful to the caseworkers in accomplishing and reaching a goal, how do we not make it so broad that we leave them floundering?
That's a great question, and I'm not sure. I think all of us should be careful about trying to be too certain about how this will play out. But I think it has to be done in part with the mandates coming out of your office, Bev, which is that just because we don't call something child abuse doesn't mean that cases don't get open. So it's trying to really make clearer in the way the information comes from the department, the mandates to counties, the training of workers, that there's a built-in triage in our system. But that doesn't require us to say that because this isn't child abuse, that we do nothing. This simplification is about what you really think the purpose of the CPSL is. And if it is, again, to require the reporting of kids most at risk, to make sure that certain categories of people are mandated to do that, to insist on a really swift investigation, to bring in multidisciplinary teams, as is required in the law, and use of risk assessments, and to create the registry, that message needs to be clear and concrete, but it doesn't mean to say that we're not doing anything about anybody else. I mean, I think the one thing I would say about the testimony this morning is that at times it seemed to conflate CPS with child welfare as though they were the same things. And while they overlap, they're not identical. CPS is a component of a much larger child protection system. So I think that's partly messaging and training and resources, as you've heard. But I don't think it could all just be fixed by the law alone without doing much more. So.
And if I can just say, too, I appreciate the fact that you acknowledge that there are, just because the CPS law doesn't call something child abuse doesn't mean that law enforcement isn't looking at it as child abuse in the bigger concept. And I think that that is a misconception out there in the public, that if children and youth aren't investigating it, then for some reason it's not child abuse, and that just is not true. And I know my prosecutor friends will echo that as well, but thank you very much.
And even though I'm not a prosecutor, I would echo that, too. I mean, I think it's, you know.
And I appreciate the fact that you did recognize that in your earlier comments about certain things do need to be left to law enforcement to handle, and I would tend to agree with that. Thank you.
Mr. Schwartz, it's a pleasure seeing you again. And I don't have a question. I want to publicly thank you for your dedication to children's rights over the many decades. So I appreciate that.
Thank you. I'm as young as you. I really do appreciate that.
Hi, Bob. I do have one question. So one of the things that you said was to basically get rid of GPS. I heard you say those words. And so tell me what you're going to
statute.
In statute. So tell me what you would do with it, because
I
think one of the things that I hope we're learning is that we don't count like a lot of cases that are really quite serious and chronic and bad things happen, and those are generally in those GPS cases. So just describe for me kind of what your vision would be at a 30,000-foot level with what you do with all of that, with that statute.
Well, I would move, and again, as I say, I come at this with a great deal of uncertainty. But I would move it back to the Public Welfare Code where it was originally, and have DPW regulate it. And there, between regulations, bulletins, figure out the data you want to collect, play with it in a way that statutes don't often provide. I think there's a lot of room for evidence and research, as Dean Gellis said, with pilot county opportunities. It's much easier to do that through a regulatory framework than through a statutory framework. I wouldn't, when I say eliminate it, I didn't mean eliminate the concept, because that's an important intermediate place. And nor did I mean to suggest that we wouldn't collect data and know which children fall into which categories of abuse and where that occurs. But I wouldn't have it in a statute that is about mandatory reporting and then say over here, now we're going to talk about stuff that's not mandatory and muddy the waters. I mean, that's really what I'm saying. I think that the CPSL ought to be clear in terms of what it's doing, but keep GPS principles elsewhere and capture what they're trying to do.
Okay. Thank you.
Thank you, Bob. You did a great job as always. I want to take this opportunity and talk to or ask your thoughts on, of course, our definition of dependency. And the Casey Family Programs, after David Sanders testified, put together some information, and I just have it sitting in front of me. And one of the things that looked like an outlier for Pennsylvania was we are concerned, I'm going to use their wording, concerned to an unusual degree with socialization, education, and parental control. And as we talk about what is child abuse, what is neglect, what things should we be involved with and shouldn't we, I just think it's important that we look at what does that mean. And I think we've become the end-all be-all for anything involving a child within a community, because I'm not sure we've built community resources the way we need to, such as truancy issues. Clearly, I think most would agree that truancy in a young child is a risk factor for other problem behaviors. when a child pulls himself away from school, and children, youth agencies need to get involved. But a 16-year-old who is truant from school may be a different issue, and I'm not sure what the child welfare system is expected to do to resolve that issue, other than look at it or other children that the same pattern might be repeated. But education, I'm not sure what their role is anymore. So, again, that has become a child welfare issue. Parents who, and we have it in here, any child who's committed acts of habitual disobedience. I guess I could have given all my kids to children and youth.
That's of the reasonable commands of the parents. So.
Yeah. So, but again, have we gotten to a point where our system is saying, okay, if there's a problem with your child, we'll get involved, and when the agency says, I can't deal with my 15-year-old anymore, and I can tell you this is happening because I've been traveling all over and I see it. In fact, our largest percentage of, we've been doing research on kids going into care, reentering care, are 13 to 17-year-olds who are coming back in. And when we see why they're coming back in, it is for that, that habitual disobedience, behavior problems. So I guess my question is really, are we going too far in that direction? Because when I ask our children youth administrators, they're telling us they're not spending time on abuse, real abuse and neglect. They're spending time on teenagers who parents don't have the parenting skills to deal with. And what are your thoughts on what we should do?
Well, I think that's is probably something that requires a longer conversation than we can have here. I think that the way, and you're right, that probably half the kids coming into the system in every county are teenagers these days, and there's a great divide between the early childhood and the older. So I think the challenge, is probably less about the CPSL and its role, but how one thinks of the obligations of the Child Welfare Agency and how it's funded. So the question for you is whether or not your recommendations with respect to CPSL are made in that context or in terms of the CPSL alone, without worrying about what's going on in the rest of the system. And I would actually urge you to think about the child protection system you want, and then have that compete within the larger debate over how children and youth agencies should operate. So I think they're very, very complex questions because there are all sorts of varieties of truancy, there are varieties of ungovernability, and frankly, as we know, many of the ungovernable children who are runaways are in fact victims of abuse, so that there's a lot of overlap here as well. I had thought that the needs-based budget process would address that issue. So this is a funding mechanism in the Public Welfare Code that's designed to fully fund all of the mandated services that counties present to the Department of Public Welfare. It became, the law became effective in the early 1990s, and it hasn't quite worked that way. So that also is an issue that your department may have divided views on. So I think it's worth a separate discussion, but you might want to flag that as in thinking about how you approach the CPS question.
Well, I think we have to, because the more the agency is expected to do, unfortunately with the resources we have, the less they'll be focused on real abuse and neglect, which is what we don't. We want to ensure that we are doing the job why the system was created in the first place. And my fear is that we have gotten away, that we're so busy, and this is what you'll hear from workers and supervisors and administrators all over. We've got too much to do and we're not focused. It's just one more case, and it can't be one more case. Your idea of what it's supposed to look like is what it's supposed to look like. You need the time to do it right in an abuse case. So I am worried about that. And just for needs-based, just because you brought it up, it's important to note that our department does certify it based on the needs of the counties, but the General Assembly and the governor have always had the ability to cut that when they felt it was necessary, when the revenues were not here. So a lot of that is beyond our control. So
Well, it may be a recommendation then
It may be.
to take that ability to cut away. in a way that at least preserves what you think is most central to the CPS system. But that I doubt will go very far, but it's worth giving it a shot.
Thank you.
There's very little you can take away under the Constitution from the legislature. Ultimately, that's sort of how it works.
Yeah.
Further questions?
Yes, I'm confused, and I know you're not surprised, but in 2006, there was a change made about, I think, about reports should be made regardless of the perpetrator, and people keep talking about that being problematic. Help me understand where the glitch is.
I'm not sure, again, we discuss it in our manual on child abuse in the law, which you can look at, whether it relates to the school employees piece or whether it's beyond that. I think that was tied more to schools than not, but I'm not sure, and I don't want to pretend. Jason, you probably know a lot than I do.
I think the change that came down was there was a concern that what was a mandated reporter required to report. There was a thinking that it had to be the child that actually came before them in their treatment capacity. That changed and said that mandated reporter, if they become aware of it, they have to report.
Okay, so it didn't.
What they changed certainly was also that it was you no longer had to have a child coming before you. You had to. That was one of the changes in 2006.
That it wasn't about regardless of who the perpetrator was.
I don't think so. But again, this is part of where. How esoteric this gets, and if we, between the 15 of us, we can't figure it out, that suggests a problem in the law. But there was clearly a change in going from mandatory reporting of a child coming before you in your official capacity to one that in your official capacity is abused, and that change was made.
Okay. The other thing then is, so if the old definition or the definition here that talks about a person who is, responsible for the welfare. If it is someone other than somebody that's responsible for the welfare of the child, would the child be eligible for service? Well, maybe like in the Penn State cases, for example, would that child be eligible for services?
Certainly the child would be eligible for services if the local children and youth agency opens up the case and accepts it for service. Or there may be, one of the things that we put this all on the Children and Youth Agency. We used to have a much broader community-based mental health system that provided services to children. This is trauma. These are trauma-related things. We're talking about family dynamics that play out even when a kid is abused by a stranger. I hate to come back to funding of human services generally, but whether or not they have a right to services or can get services is in parts a separate question from whether they're around anymore to be delivered, and they're stretched very thin.
And the other piece then too, what if the perpetrator's in the home as another child? Is that problematic with who would that child would be placed on the registry, for example? Is that correct?
I don't think the other child is put on the registry, but the issue of siblings and whether, because one is abused, the other is likely to abuse is fairly complicated, and that goes into the investigation. That kid would not be on the registry as an abused child necessarily, but you could certainly open a case to the family. In the recent case in Philly, they were serving other children. They knew about other siblings. It's a question, I think, of practice more than registration. Once you have an into the family, I think you could always file a dependency petition. Maybe this is the easiest way to do it. The child abuse reporting has gotten you in. You have an abused child. If you think another child is dependent, even though not abused, a dependency petition is very easy to file, which says that this meets one of the 10 definitions of dependent child, and the first definition is very broad, very broad. And then it's up to the courts, like the judges here, to make the decision about whether this is a dependent child and needs services. So that's a step process, but there's no bar to that process taking place.
Okay.
Right.
Thanks.
I don't have a question, but an observation that the last three speakers, including this one, have all either stated or implied resources. And I think this is is becoming a theme, that we undoubtedly are going to come up with some extraordinary insights and recommendations to put forward. But if there is not in some way an attempt to address resource allocation to implement these ideas, I'm not sure ultimately what the long-term benefit to the public is going to be if we don't weigh in on that question. So that's just an observation more than anything else, but I appreciate your sensitivity to that issue.
Thank you for your testimony. I just have one comment. I guess I'm a little bit concerned by the narrowing of the definition to only serious injury, no imminent risk, no GPS, because I think there's a big difference between 1972 and today insofar as we recognize that, for example, neglect is a tremendous risk for death, and we understand the idea of adverse childhood experiences, that these all add up together. And I think that once we start excluding things that maybe in 1972 weren't as clear, I think now it is clear. Imminent risk, I think some of the worst cases we've seen are really, truly imminent risk. And if it weren't for that statute, CPS would have their hands tied because nothing yet had happened to the child. And we always hear, all the children died in a house fire because X, Y, and Z. And there clearly was imminent risk. And it kind of allows you to get involved in the highest risk kids. So I think the idea of age, like we know the youngest kids are the highest risk, all these risk factors. So I would get concerned about narrowing it so much that you really take out the kids that we now know are highest risk. So I don't know if you have a comment about that.
No, I think that's fair. I think the question is how you write that into a statute to get to the kids that you're talking about without having investigations of kids who for whom the definition is far too broad. A parent throws a baseball bat in anger, missing the child meets the definition now. The neglect cases, again, I would say part of the challenge is whether you can craft a definition related to neglect that's different than what we have now, that will trigger an investigation in a timely enough, at the right time frame. I think generally with neglect, although we know that kids are at high risk of long-term harm, their short-term safety is less in peril. So you need to, that's part of differentiated response. We've talked about differential response. There are many definitions of it and versions of it. That's one of them, so that you take the kid whose safety is imperiled now and make sure you get that kid out of the house or into a safe position quickly. The neglect kid may be different. And I'm not saying they should not be in the system or that the system shouldn't have the ability to remove the child from the home. It's a question of what you want to use the CPSL to do.
I guess I'd make one comment, and maybe this is so I have to tell you, at our hospital, the entire UPMC system, which is huge, the interpretation is a GPS is not a report of abuse. So we require parental permission to do a GPS. That, I don't think, was the intent of GPS. And I think by what you're saying, you're going to do the same thing where almost all these cases are not child abuse. So people could interpret them as not being part of mandated reporting, because mandated reporting is for child abuse. And so I think we have to be very careful, because once you have to require parental permission, you lose kids right at the start, and those might be the highest risk ones where the parent. So I think by defining something as child abuse, you allow the mandated reporter to report without fear of recrimination, all these things. So there is something to be said for defining concern of abuse in a very large umbrella to protect mandated reporters.
In the early days of the CPSL, before bureaucracies emerged, when Children's Hospital would get a physician or a social worker would see the kind of case you're talking about, they would call us, and we would file a dependency petition on behalf of the child, because the Juvenile Act says any person can file a dependency petition. and that would get the case before a judge and would get the Children and Youth Agency in play. That provision is still in the law, although it's been suspended by rule now, and it's to allow children and youth agencies to screen and to make decisions about that in a different way. But the fact that it's not a child abuse case doesn't mean that there's no vehicle for getting that case in. I mean, you could call Kids Voice and ask them to file dependency petitions on those cases. They could do that.
I guess that gets concerned about complexity. I guess we're going back to how do we be as simple as possible?
Right.
And once you start bringing all these different ways to do things, I think it gets more complicated.
Well, that's right. That's the million-dollar question. I'm glad you're sorting it out and not me. Okay.
Thank you. Thank you. Thank you. First, thank you. I am humbled to be called here today to speak to this esteemed panel. I want to share with you a story, and probably each and every one of you have a story like this, but it's the story that continues to keep me focused on why we do what we do in the child abuse arena. I had a sexual abuse case of a little boy named Emmanuel. And Emmanuel was so fearful when he went into the courtroom. He couldn't speak. No matter how much preparation we did and how much time we spent and how much I got to know him, the moment he walked into the courtroom, when the defendant was in the room, he could not speak. And the defendant was his grandmother's boyfriend. The judge allowed me to go a little bit closer to him to see if I could get him to speak, and he wouldn't speak. And he said, please come closer, and closer, and closer. And I spent the entire direct examination of Emmanuel on my knees so as not to block the jury view of him. And at that moment in time, I realized that this mission, vocation, is a gift and is like living a prayer. So I say this out loud to share this one message. We may have done these things 1,000 times, or 2,000 times, or 10,000 times. But I leave everyone that hears this testimony with this one meme. Please allow us to remember that it's someone's first time. And if we stay focused on the humanity of that, and that is at the grassroots to everyone who does this, I think it helps build the rapport that we need to build to implement broad, wide, and sweeping changes to the system. So I share that longer story than I wanted of Emmanuel with you to have a centeredness about what we are doing and how we move this through. I'm a child abuse prosecutor by training. I started in the district attorney's office in 1986 in the domestic violence unit. I moved to the child abuse unit where I did physical and sexual abuse cases. I did adult sexual assault cases and then homicide that involved child abuse, domestic violence, and sexual abuse. In those just shy of 20 years in doing that, my view of the world is not focused on the CPS system the way in which earlier speakers are focused. And in fact, my lens is from a different angle, and it's where the most serious cases, those criminal cases, intersect with DHS in my case. And a few observations about that. Every single individual who I intersected with was well-intentioned and well-meaning. They often did not have the tools, the time, or the training. And in my experience, what I would bring to your attention is the broad subject matter of coordination, and I'll get more specific about mechanics in a minute, but coordination in the area of training, tracking, and investigations. From the perspective of a prosecutor who sees the worst of the worst, I can't tell you how many times I know a case was called into DHS before it got to the criminal system. That's a tragedy. But it's no one individual's fault. It is zooming out the lack of, again, training, tracking, and good coordination in investigations. So one case that I can think of that demonstrates this best is a counselor who was touching a complainant, a young teenage complainant, in the context of counseling because she was troubled. She reported that touching. He was not touching her on any of those bullseye area that would immediately make anyone think that it's a crime. But he was touching her on her thigh, on the perimeter of her bra strap through her clothing, and in areas that were just uncomfortable in the context of counseling. That was called in to the hotline, and it was not taken for a whole variety of reasons. And there are people who can speak to the perpetrator conundrum better than me, and there are people that can speak to the definition conundrum in the hotline arena better than me. But that complainant made her way to the police, and there was an officer in the Sex Crime Special Victims Unit that understood and was trained and understood enough to know that the definition of indecent assault was touching of the sexual or other intimate parts. And he brought it to the district attorney's office. And we listened to her and listened to her account, and it was as credible as the day was long. And we made the decision to arrest in that case. Upon that arrest, we learned that there was a report from 8 years earlier, which was now out of the statute of limitations, of yet another student who went to this same counselor for similar teenage issues, who was touched in a more significant way that made out a crime. That was never picked up anywhere. And it was left to sit in some archives. I happen to have that same trained investigator that understood the more recent case that came to me understand the intersections and understand that in these cases there is no clear, concrete, physical evidence. We have typically a word against word, and in these cases with children we have the word of the good counselor, or the good adult, or the good teacher, or the good doctor, lawyer, butcher, baker, candlestick maker, versus the troubled child. We already have a differential in power and perception. And so with that being said, this takes me to the point about investigations. Investigations have to be done by trained individuals, not catch as catch can, because we're losing things and they're falling through the cracks. And so what does a good investigation look like in a word against word case? It looks like good forensic interviewing. It's not just the facts, ma'am. Was your purse stolen? How much was in it? Did you cancel your credit cards? What time did that happen? A dragnet, just the facts, ma'am, investigation doesn't cut it, does not get us to the issue, Dr. Christian, of intent. What is someone's intent? A good investigation means a trained eye on not only the words that are used, but how they are said, when they are said, the context that they are said in, the context of the disclosure, who was present, does that affect what was said and how it was said? Was there something different said? Who are the attendant witnesses to the relationship? What are the motives and biases? What are the details used? And not the details that go to the bullseye event, but the details that describe the event in the broader context that help you believe whether something happened or didn't happen. Where is the corroboration? What forms of corroboration is there available? And how do we access it? When you want to talk about the low number of substantiated cases, it is directly tied to our inability to capture how to do a good investigation. So I don't want to talk about the problem all day, because we could. I want to talk about the solution. How do we get into the weeds on the ground with our soldiers in the field whose eyes are on these cases, the reporter, the direct person, the people who are called out immediately or initially? How do we get there? And I think we get there in two ways. One, it starts at the top, and I think it's a tone at the top, which is what you all are here to do. And this is a beautiful tip of the iceberg that I think will melt down beautifully. But it starts at the top with a centralized plan and a centralized way to approach these things. And I will share this with you at some point later. But I would like us to have at this top, drawing from all the experts, templates that say, what do we need to ask? The things I just outlined and more. But templates that we create as a clearinghouse. We have an ombudsperson, perhaps, at the tip of this. We have regional multidisciplinary trainers that we set up in different regions. And we put a premium on training. I can't tell you how many times I've gone to places that have, these are the required trainings, 12 or 20 of them, and one is done because the time wasn't right or the schedule wasn't right or there wasn't enough funding or we couldn't send someone there. We have to put a premium on that training, and that training has to be robust and informed and give people the tools. They're competent. They're willing. They just need the tools. They need to hear. They need to learn. They need to train. And how do we create those templates? By getting the most vexing cases. What are they? And talk them through here. Talk through the most challenging ones. Create the templates for that. And not only the templates of what to ask, but help people know what to do, what to say, and where to go. Because sometimes the mechanics of it are the stumbling blocks. So that's my rant on investigations and templates, coordination at the top, and then trickling it down into the field, into those people who are charged with the investigations. The other thing that I would like to share around this is tracking. We should have some centralized ability to track, and we don't. We should have the ability to track not only across close state lines, New Jersey, Delaware, but the ability to track within. We are not doing that. And the ability to track between and among agencies. I heard someone reference some statute, criminal statute, that they said they couldn't share something in their investigation with the DHS worker. I don't know why we shouldn't be doing that if the goal is child protection. We should be sharing information, and we should be sharing it in a unified, centralized way. What is my idea? Again, I want to go to a solution here. Software. We have the capacity now. We have lots of large companies that will do it. I heard earlier today about some tracking software in a different context, but we can do it. A lot of my thinking about tracking comes from the context of the college and university arena. In implementing Title IX, and that is sexual harassment and handling sexual misconduct in the college campus, I've thought a lot about how to develop policy and how to track. And we need to have a software, and I've developed in a different context software to track and sequence events around sexual misconduct in a different context, but it's easily applicable, and I know it exists in other places that can be designed so that everyone, when they sit down at their desk, sees the same dashboard, sees the same sequencing of events, sees the same decision trees. There's tracking that I know of in the hospital setting. For doctors, when someone comes in with this ailment, there are questions and there are things that have to be filled out where you don't get to the next screen until you answer that. Why not have that on every desktop? Why not have that with the template forms and the sequencing of events and the coordination of agencies, and that the agencies can also plug in, and when a name appears in two places, we have the ability to do that now. And so I highly recommend software to help with the tracking and the coordination. And I know my colleague has so many great things to say, so I want to stop here with that, and I'd be happy to share anything else that you'd like to ask.
So, Your Honor, with your permission, then I'll proceed, and we'll both be available for questions afterwards. I want to thank Your Honor and as chairman and everyone here on the board for the opportunity to be present. I am by training, as my colleague Gina is, a child abuse prosecutor. I did this work for the better part of 14 years in the city and county of Philadelphia, and I think that I bring to this table both a micro and a macro view. I served in our family violence and sexual assault unit for 6 years, trying cases day in and day out. Often had Dr. Christian on the witness stand, Maria McColgan, who you heard from a few weeks earlier, worked closely with Frank Cervellin as a child advocate. And so I'm familiar with many of the parties that are involved in many of the issues. Like Gina, my perspective is that of the law enforcement criminal justice response. I also, though, have the additional macro process, and that macro is that the last 5 years of my career at the District Attorney's Office, I served as first the Assistant Chief and then the Chief of our Juvenile Court Unit. And in Philadelphia, our family court, by Constitution, hears the inception of every child abuse case, which meant that for 5 years, with the exception of homicides, every arrest of an adult or a juvenile for any type of abuse involving a child, whether it be sexual, physical, the victim of an armed robbery, the victim of a bike theft, came across my desk for a review. And so have that 5-year broader lens perspective, and in that context could see the challenges in investigation, the challenges with the intersection of both law enforcement investigators as well as child protective service workers, information coming in and from hospitals, some of which are far better at it than others, and private pediatricians and things along those lines. And really able to identify at that level the cases where our children were the most vulnerable. And I will speak to 2 of those areas. I will tell you that I echo wholeheartedly the testimony by Anne Marie Ambrose, by Frank Cervellin, and by Maria McColgan, that you have heard ad nauseum definitional concerns about non-accidental, about perpetrator, about how we structure some of those pieces. And I'm not going to go through and readdress those again. I think they've been put together before you beautifully with some wonderful solutions and suggestions. What I'd like to focus on more is the systemic, I think, process, and much like Gina speaks of, the mechanics that are involved. Looking at child abuse and what we know about child abuse. Our children are abused by those people who are known and trusted. It is typically the parent or the caregiver, and in the case of abuse outside the home, by someone who is trusted by the parent or the caregiver. And so the first question this committee will have to address is, do we limit it to just abuse that happens within the home, or do we consider the broader spectrum of looking at the schools and the institutions that our children are in on a daily basis? I can't answer that question for you. I can tell you that the attempt now, I believe, and I won't go into a deeper discussion about that, but the attempt for how we deal with the school employee in the school setting is clumsy. It creates a dual-tiered system that doesn't make a lot of sense. And Dr. Christian, I don't consider myself a lawyer. I consider myself still, although I'm no longer with the DA's office, a child abuse prosecutor. But it's very hard. I tried to teach on it to the Bar Institute not too long ago. And it's difficult explaining to someone, if you sit in this house, you have to report here, but if you sit in this house and your child is abused by someone, you have to report here. And it's a very difficult conundrum for folks to follow. In response to a question that came from this side about what other states are doing, I think it's Delaware, New Jersey, and Maryland, who all are much broader in terms of any person required to report, and our other neighboring states, West Virginia and Ohio, are like us, certainly enumerated professionals. And so there is wide variety in our region of responses in terms of how we turn to those things. But circling back now, we currently have a system that allows us to report against a perpetrator or, and this was the question, Ms. Rumberg, I believe you had raised to Mr. Schwartz, a child who we suspect to be a victim of child abuse, whether or not that abuse was committed by a perpetrator. And so we end up with the phone call into the hotline by an individual who is not a perpetrator, and a hotline that doesn't know what to do with that information. And perhaps they take it, triage it, do their investigation, and determine it's law enforcement and make that referral. And perhaps they don't. They stop there, they hang up the phone, it's not our mandate. And I can't tell you the number of times over the years, anecdotally, that I've heard from law enforcement, I called, they wouldn't take it. Or I've looked at cases where DHS was involved and never stopped to pick up the phone and call law enforcement. So I am a huge advocate for a central process that when the notification gets made to one, it automatically gets made to both, and let each of those heads come in and triage and decide, yes, it's mine, no, it's not mine. And we can look in the past to cases where there have been tremendous finger pointing in three directions. And I draw your attention to the case of Della Marvera, who was a young girl who was kidnapped at the age of 10 days. The ME's office, law enforcement, and the fire marshal did not talk to one another. And so misinformation from all three resulted in the fact that some folks knew that we had a child who could not have been incinerated from a fire. Other folks did not. And this child, as you may recall, was found alive 6 years later. She had been kidnapped by a family cousin. And had those three systems been talking, perhaps there would have been a prompt and immediate investigation. There were easily identifiable facts that could have prevented that child having losing her entire foundation and 6 years of her life for what she knows and believes to be true. We have the same problems with child abuse, child protective services, not speaking with and not talking to law enforcement. And I suggest, and I know, Dr. Berger, you raised this question several weeks back at one of the sessions in terms of how we coordinate information back, so that information should not be a one-stop flow into the hotline, but that information is responded back. And an MDT, a multidisciplinary team, is a true team. It is a team where it is an ongoing coordination and interaction, where we are involving all parties in the process. We do that beautifully right now in some of our counties with our in Philadelphia, we have the Philadelphia Children's Alliance. There are right now 21 child advocacy centers across the state. 13 accredited, 8 in other various forms. And I sympathize. 2.5 hours is far too long to drive. By the time you've gotten a child 2.5 hours, they're not ready, willing, or able to talk to anybody about anything. And we need to have, I believe, state-funded resources for child advocacy centers that exist across our state and are available to all of our children, not just the children who happen to live in cities who have vibrant nonprofit institutions who are serving a function that is our function. It is our mandate as a state employee, as a city employee, as a child protective services, as a child welfare worker. And I believe that you'll hear more about that when you hear from those folks, but I cannot tell you more strenuously how I believe that we need to adopt that model and adopt it broadly. So Gina talks to us about the coordination and investigation and having specific standards. I think we need to develop and define best practices, so that when best practices are not followed, we have a standard to which folks can be held accountable, so that we know a child who comes into my county gets the same response as in Blair County or Dauphin County or Bucks County or Montgomery County. And right now, that is not the case. And we are hamstrung by the fact that we have 67 counties and hundreds, if not more, of townships and municipalities. And I know in Philadelphia, you can walk in as a child and you can get one of 30 investigators, some who are better than others. If I am just across the county line, it depends on my municipality and my township. And the level of training that that frontline police officer or social worker has is going to vary disparately. And it's going to impact the effect and the response that we are able to give to that child. The two areas that I wanted to focus on in terms of our most challenging population, our most challenging children, the first we've talked about, I believe, and that's our non-speaking, non-verbal child who is injured in a home where there is more than one perpetrator. And I suggest that those are incredibly difficult cases. And what we do in response is twofold. One, we change our definition. That's easy. But two, we change our response. And we have right now a multidisciplinary team that exists, at least within Philadelphia, for cases for a child who is already in the system and there's a new allegation of abuse that comes in. And it's kicked up to a higher level of review by more experienced social workers and by more folks involved at the table from various disciplines. And I'm suggesting that we need to do that for every one of these cases with our nonverbal children who we are not able to identify the perpetrator in. We have the non-fatality review committees. We also have the Fatality Review Committee, and those are through Act 33. There is another class of high-risk children that I believe need to be in that category to be reviewed. And the class that I want to really spend 2 or 3 minutes talking about, because it's one that has been, it was an eye-opener to me, and it was a focus of my work at the DA's office for the 14 years that I was there. And that's where we have a child between any age, 3 and 18, who makes an allegation of physical or sexual abuse by father, boyfriend, stepfather, could be mother. I'm going to speak in the terms of male-female dynamics, even though we know it happens both ways. And the parent, the non-offending caregiver, is not supportive of those allegations. And we have a gap in service that is set up because our Department of Human Services comes in and says, the home is appropriate, there is food in the refrigerator, the lights are on, the electricity is in, and water is running, and the child is otherwise going to school. The perpetrator is out of the house because he has been incarcerated through the criminal justice system. We're done on the Child Protective Services side. We're going to bow out of this. On my side, as a prosecutor now, I have this child coming in front of me, and what I don't know, and what I learned through subpoenas and through prison tapes, is that mom is on the phone with him every night, that mom is selling the food stamps to pay for his bail, that mom is directly or indirectly influencing that child to recant. And I now have a child on a case that I cannot prosecute, and oftentimes on a mother that I cannot arrest because this might be the last best resource that this child has in her life. And it is an education issue, and it is a resource issue. This is a woman who perhaps has nobody else. It's similar dynamics to what we see in domestic violence. The overlay is here in child abuse cases. And when my DAs, at my direction, would call Department of Human Services and say, I have this concern, the answer is, well, that's not our problem. We're not here to cooperate with law enforcement. We're not here to ensure mom brings the child to court. And there's a recantation, and that affects now our understanding of what happened. And so recantation, I think that we all know, is a very normal and natural part of the process of disclosure for children. And the question should not be when we receive recantation, why is the child, recantation should not deter us from our full investigation, because recantation is more often the case than it is not. And it doesn't mean the abuse didn't happen. It means there's some other influences going on in the child. So for those cases, I believe the response needs to be that multidisciplinary approach. We have some cases where our judges are great and they step in and they are really able to understand and they remove the child from the home when appropriate, or they put in other sanctions or restrictions, including contact or lack of contact. We have other cases where the judges in our dependency court say, we can't help and there's nothing we can do about that process. And we send these children, leave them in their homes. We withdraw the cases in criminal court. The offender goes exactly where we'd expect him to go, which is right back to that home, and that child continues to be abused. This is not anecdotal. This is systemic. This is something that I have seen across the board. I can tell you I have been to the college graduation of a young woman who reported when she was 7. DHS stayed open for 3 years, closed the case out because mom said and did the right things. Mom then moved back in with grandmother and brought her boyfriend in. Boyfriend had been the abuser. Boyfriend, in the meantime, applied for, became a Philadelphia police officer, and continued to rape that child from the ages of 14 to 18 before she finally reported again when she was a senior in high school. That child is one of our success stories. She's a college graduate. She's moved forward. That child never rekindled that relationship with her mother, and that was a failure of our system on many fronts to not deal with and address those issues. That one we could successfully prosecute because she was strong and had some resiliency about her. There are many others that we have had to withdraw, countless number of cases we've had to withdraw. The last place that I want to talk about is just very briefly, our courts are not child-friendly. There is nothing about court that is child-friendly. Children do not communicate in a question and answer forum. Children do not come into a room such as this and have 12 jurors where they have to talk about their most intimate body parts. And they're talking about, mind you, something we've taught them is wrong. So we start at the basic level, good touch, bad touch. What are we saying to our children? Don't let anybody take your bike. Don't leave it out in the rain. Don't hit your brother and sister. Don't let anybody touch your private parts. So when they have now let somebody touch their private parts, they have let us down. And so this is a paradigm shift that has to start with early education. We send mothers home from a hospital by making sure that they have a car seat. But we don't necessarily know that they have a house that is suitable with the resources in place, nor have we had the discussion with parents about this is hard. Parenting is difficult. You will be frustrated. Here are the resources in your community, whether it be through clergy, whether it be through counseling, whether it be just a conversation through that process where we identify who will you turn to if it is complicated. What child care provisions do you have in mind? And those are the education pieces that we talk about, the training pieces that we talk about at every level, starting from birth, in our schools, what we teach and show to parents, what we teach our judges. I am often battling, with all due respect to your honors who are here, there is a vast differential in the knowledge and intuitive sense that our judges have about child abuse, and I am often battling not just a defense attorney, not just having a child talk about these issues in a public courtroom, but also battling preconceived notions and biases perhaps by a judge who has not had the education. There are many myths and misconceptions out there about child abuse, what it is, what it looks like, who commits it, and unless we're educating those folks who are directly involved, not just our investigators, but those who are our decision makers, then we're doing our children a disservice. We have a statute right now that allows us to have every child testify outside of the presence of the jury. Yet I'm not aware of any courthouse in Philadelphia that is trained and set up in a forensic interviewing setting, or I'm sorry, across the state of Pennsylvania, where we have a one-way mirror, that the child can testify in a comfortable environment, speaking directly with first the prosecutor and then the defense attorney while the jury observes. We can do it through closed-circuit television right now, but you are not going to decide a credibility case based on what you see through a little screen. You need to have that child live in front of you. And so there are so many things systemically that we can do to support our children. I recognize much of this is beyond the purview of this task force, but I wanted to share these concerns because they are the lens and the filter for which we have to view all angles and how this small piece, which is a magnanimous piece, fits into the broader puzzle. And so with that, at 1 o'clock, I know that's your witching hour, we will stay as long as need for questions by the task force.
Oh, I get to start. Okay. I said thank you both. That was really important. I think that really reflects a lot of what we see as well. I just want to make one question comment about the lack of judge education. This is something actually that we've talked about in terms of the lack of consistency within the state at every level, not just CPS, but law enforcement positions, is in large part due to the lack of training. And I joke that when we go for all the preliminary hearings at these magistrates, and the person before I testify is someone who's fighting a traffic ticket, and then I come in with a child with 18 fractures, and it's the same judge who's doing the traffic ticket first, and then me, and then after there's probably something, also unrelated. And there's no required training for these judges. And in medicine, you don't do brain surgery without license. You don't do, dermatology without a license. But would you suggest any kind of requirement for anybody at any level to investigate, to evaluate, to do anything like that, particularly on the law enforcement judicial side?
Absolutely. And I think Gina could speak to the fact that there is that requirement for attorneys who do capital cases, and our judges are not permitted to do homicide cases. And yet I would suggest that many of our child abuse cases are far more complex than a traditional homicide case. I did not speak to the other thing, Dr. Berger, which is we also, I believe, fully in a dedicated child abuse court with an expedited time frame such that we're not waiting 3 to 6 months for preliminary hearing, a year to 2 for a trial.
In the federal context, through the Title IX rubric, as a condition of maintaining your federal funding as a college or university, you are required to provide training to your entire population, to your implementers of programs and systems around sexual misconduct, investigations, etc., and to your decision makers as a condition of federal funding. So there are models out there that require it, and I would absolutely require training of everyone involved in the system from top to bottom.
Resources. I've heard it from 5 of you now, that the training and tracking and investigation is right on, makes sense. The raising the literacy level of these professionals who come in contact makes sense. Being able to have the resources to field the calls that come in, apparently they're not being responded to, makes sense. But unless there's some attempt to address the reality of providing resources for these opportunities, which are very well articulated, I'm not exactly sure what impact this is going to have on the long term. The other observation is, and I'm not a professional in this field, a lot of these cases don't get resolved with 1 or 2 interactions. These are long-term, systemic issues that require long-term remediation. And I haven't seen or heard yet where the resources to provide that level of service are available. Could you comment about that maybe, perhaps, if I'm on the right street?
I refuse to give up. I am as tenacious as they come around this issue. So on the resource question, there are a lot of people like me and Leslie out there. There are lots of prosecutors who still believe that their child abuse work was the most important work that they've ever done. Why don't we tap those? Why don't we tap those regionally? Tap those folks who have done this, who really have that skill set. And I don't know how you as a body can do that. You know, one way is to identify all the child abuse prosecutors or counsel in the Child Protective Services system that are willing to be part of your regional teams. And don't drain them, but tap them quarterly and have a team that rotates so that they can give of their time, because they will. They absolutely will. There are grants out there. They're few and far between, but there are. There are also organizations that have robust pro bono programs. And the trick is to find those trained and competent individuals to do it, but I think they're out there. I know that Ballard Spahr does pro bono work for Prevent Child Abuse PA. I know that there are other law firms across this city that work with the support center. And Frank Cervone is a wonderful source of finding those places that have some resources to give. But I also do think it's time to ask our state to put its money where its mouth is. A little bit. I mean, I know there are competing things, and I am the first to say I don't know what I don't know about that, but it's pretty clear to me that this is low on the totem pole because this constituency has the smallest voices.
I think that's absolutely right. And I'd like us to go beyond descriptive to prescriptive, so that we're not just sitting here describing the problem, but at least give some thought to what we might be able to do to get more at the prescription side of this thing, so that we venture into the field of finding answers, not just describing the problem. Even with your idea of a centralized tracking system, I mean, that's common sense, Dick and Jane see spot run. But, you know, if you don't have the ability to authorize or implement that, I'm not sure it goes beyond just being a brilliant idea. So I hope, Mr. Chairman, that as we go forward, that this issue of identifying and providing resources to these extraordinary people in these fields is a purview and a legitimate concern of this group that's sitting here. So that at the end of this process, there's two reports. One describes the intelligence, and the other might be a smaller report that says, here's where the legislature and the governor and others might begin to look for prescriptive opportunities.
I am a prosecutor, used to be, am again, and so that I'm thinking that one of the great ways that we solve a lot of these problems is to lock up the source of the problem, and the rest of it, there are other things that may be helpful, but that's number one. I've been concerned, a couple of things have cropped up, a couple of times the idea has cropped up, and I heard it today, that victim advocates would actually discourage victims from participating in CAC interviews. And of course, when you have a particularly young victim and you've got mom who may be at least ambivalent about the prosecution, as you were relating, that may fall on particularly receptive ears. I suspect that's not a problem you've had in Philadelphia that you've directly experienced, but I've heard about it in various parts of the state. I know, Delilah, you had advanced, one of your group had expressed concerns about the questioning or whether CACs were a good thing, and you know, I think they are the be-all and end-all of how you deal with victims and build successful cases. So can either of you or both react to that?
I think that we can say we've seen the same issue in the college and university setting. that part of the Title IX requirements that have come in talk about proceeding with a case even absent a complainant's consent or confidentiality request, and victim advocates have been sort of up in arms about that issue. And what you find is when you sit down and you bring people to the same table and you have a conversation about what the goals are, what my perspective is, what your perspective is, you identify the places where there are synergies. We've not had that issue in Philadelphia, to my knowledge, on the Child Advocacy Center. And I think that if you take the time to have those personal conversations, find out what the source of the objection is, find out why there's a fear in the process, that you'll be able to identify it and move through that. I think that's the simple answer. We're never going to get everybody on the same page, but we can at least try to get most everybody reading the same book.
And let me just say that, Bucks, we have one of the programs that just actually got certified the first time around, or whatever it is, accredited nationally. And our victim organization provides the physical plant. In fact, I think I'm going to miss tonight the opening of a third location because Bucks County is fairly spread out, so that everybody working together it's inconceivable to me that anything else would be the case. But obviously it isn't. Let me just throw out, and I don't know that this even needs a response, but I guess I can't get over thinking about the record at least a little bit. One of the things that we forget, and I think perhaps those who are not familiar with criminal investigation may forget, is that in a lot of these cases, and some of them it's going to be oath on oath, and that's just what the nature of the case is, but when a case is presented, and especially when we can get wind of it before the perpetrator may be aware that there is an investigation, there are wonderful opportunities for particularly wiring somebody up or getting other corroborative information that may be dispositive. In the best of all possible worlds, you'll just have a slam dunk. That's one of the things that makes the promptest possible connection with the criminal justice system, with the prosecutor, with the police, and with the prosecutor, really important. And I think that sometimes gets lost. We're thinking in terms of the CPSL system and providing services and what do we do here and who gets. But if there has been a crime, or there's reason to believe there's been a crime, man, every minute lost may make the difference between a kid going through torment on the stand and the kid never having to testify because we've got the guy by his own hoist. So I don't know. I see you nodding.
Well, because I can share with you that is done in some counties that have the time and resources, and there are other counties that have never done a wiretap on a child abuse case. And I'm speaking of large counties as well, not just our smaller counties. And so that brings us back to the need for standards, best practices, what should we be doing in these cases.
One of the things that occurs in the college and university setting is there's a directive that whoever receives the report has to say to a complainant and think about the importance of preservation of evidence. So it is prioritized, and especially in child abuse cases, you're absolutely right, Dave. It can make or break a case, and it could make or break whether a child has to go through a horrible experience in the court system. So preservation of evidence should be written in some way, shape, or form as a key component, as a first line of review, thought, and consideration.
Thank you. Doctor.
Hello, ladies.
Hi.
Nice to see you both again. I just want to follow up, I think, something that Dave just touched about, and Leslie, you also talked about, which was kind of this concept of kind of almost like a single front door that allows for a few things. And I think you highlighted that need for child welfare and law enforcement to kind of get their hands on a case at the same time. But there's another reason to have a single front door, and that's because the general public has no idea of, the differences between a child welfare case and a law enforcement case, and who do I call, and if it's not child welfare, then I should really call the police. I mean, if we had a system where everybody just called one place and the system was capable of effectively kind of triaging the case appropriately, that would be great. But, my experience is that there have been systems or there have been mandates in place, even in Philadelphia, I assume throughout the state, but somebody will correct me, where child welfare and law enforcement are mandated to work together, and they're supposed to report to each other, and they're supposed to do co-investigations. But, for example, I saw a child 2 weeks ago, and I found out, and that weekend when I saw that child, I contacted our hospital social worker, child welfare was involved, and I said, the police need to be involved in this case. You need to call the police. And I found out yesterday that the police didn't get the report for 5 days. So I just want some comments from you about what your experience is with, how we mandate law enforcement and child welfare to work together, how in reality that plays out, and if you have any ideas about what we could do about that. If your experience is like mine.
Well, my experience is most definitely the same as yours. And referencing back to Gina, I tried one jury trial 3 times because the jury could not get over the fact that the DHS social worker had not reported it to police for 3 days, and the child was never told, despite the fact the last sexual act had been that morning, taken for a hospital exam, because she didn't know that that's what she was supposed to do. And so the easy, short answer is policies and protocols. I don't know what the procedure is. I don't know if there's a policy when it comes into the hotline, who makes that notification. But it should be spelled out very clearly who makes the notification. It also should be some sort of a tracking method and a tracking mechanism to make sure that the notification gets made both ways and kept in that central system. It brings up the issue, we often have city solicitors calling us after the fact to say, can you tell us what happened with your case? Because there's no built-in automatic mechanism where the criminal justice system reports back to Department of Human Services what the effect of our case is. And we didn't even talk about the fact that we have administrative judges, that if we have a frontline worker who substantiates the case, the offender appeals. We have an administrative judge who more often than not is discounting a significant percentage of those cases. And if you've not yet done so, I'd suggest having a city solicitor from Children and Youth Services come in and address you on that particular issue, what happens when we get to the DPW state administrator level to try and sustain the appeals on those cases. I know I went a little off your train track there. I think Gina's going to bring us back onto it.
So, Cindy, thinking about this very issue, the system must have a single point of contact. So in addition to your policy writing, there has to be internal operating procedures written so those who are implementing know where to move. And even if it's not through software, which I recommend is the best way to act as a safety net, there needs to be a single point of contact that then immediately discharges to the 3 or 4 different places it has to discharge the information to. And we can create a dashboard which allows people to sign in with proper credentials so that they can coordinate for the purposes that they have to coordinate for. And I think that is key. I've seen it so many times where we're not coordinating, and not because we don't want to, but we're overworked, we're underpaid, we have too many cases, and it's stressful. And that's what's happening to everyone in the system. So to have a dashboard that pops up on your screen when you sign in every morning and a red flag comes up if it's a family that you are overseeing in DHS and it's a family that made its way into the court system, that would be a beautiful thing for that family, that those folks who are working on their case are coordinating. They don't have to come to court 12 times. They don't get dragged out of school all the time. They don't miss appointments. They don't get frustrated with the system and not show up later. I mean, there are trajectories of these things that, only living through a case do you see how it harms the child.
Are there laws that prohibit the child welfare system and the criminal system from coordinating and communicating with each other? Like in the medical systems, there are laws that are sometimes real, sometimes perceived barriers, but are there any in between criminal and child welfare?
No, actually, the law has child welfare, has law enforcement as one of the areas where you can communicate. So there's no reason not to communicate on any case-specific case. Law enforcement, because it's public record,
Well, you
So
actually
during the
see
investigation piece?
through CREA, which is the Criminal History Records Information Act, there are law enforcement bodies who will hide behind that. I use hide loosely, it's not the right word, but who respect the authority of that law and say, we will not share with you. The other problem is that there is no protocol for what happens when you do share the information.
Right.
So I often have law enforcement officers who will not give information to Department of Human Services because that information goes immediately into their progress notes, which are then easily and immediately accessible to the perpetrator.
Yeah,
who
those
has-
are the logistical issues, and that
Those are
is,
logistical
that does
issues.
happen all the time.
That does
It
happen all the time, and I'm actually very careful when I speak with the Child Protective Services worker because what my words are taken down verbatim, and so they're all written verbatim right into the records and reports. And so it's important that there be mechanisms that information can be shared confidentially and with limits as to where it can be further released.
Yeah, and that's the piece. She's absolutely right about that. Anything that law enforcement would say to children and youth, they would document in their records. They need to, and that is then possibly up for discovery.
Right. Well, my experience is when people write down what I say, they usually get it wrong, but that's okay.
And the worst problem is that they don't necessarily call you back to ask.
Just so we're clear, lawyers are people too, so I'm proud of the profession that we share. So thank you for your presentation. One of our charges is to help reinstill confidence in the child welfare system. So I want to talk about some of the things that are going on to address some of the issues that you raised with the leadership of Deputy Secretary McGrath and Kathy Utz. There is a focus on MDTs right now across the state, and implementing MDTs and making sure they exist and getting them up to speed, because that is really the tool to help bridge the communication gap that you've spent time describing. So that is in the works. And that was in the works before the Sandusky fiasco. And also, and Leslie, we talked about the Child First Pennsylvania training that trains those first responders to suspected child abuse under the MDT model. And that's rolled out, and there have been 120 professionals in 19 counties that have gone through the program. So there are things that are happening, not maybe as quickly as we would hope, but there are positive things going on. And so I think it's important to note so that the public, as they hear this, and if anybody reports anything that goes on here today, that they understand there are good things that are going on already, even though the task force has this big feat ahead. So, but thank you.
I'd like to say good morning, but it's actually afternoon. Good afternoon. I just want to tell you how much I appreciate your testimony as a prosecutor. I can relate very well to some of your experiences, and I admire both of you for the work that you've done. Your reputation precedes you throughout the district attorney's offices across the state. I know I've spoken to Gene on the phone with questions years ago, and Leslie, we still use your materials in our office to research issues that come up. And I just want to commend you for carrying that passion that you have representing children and doing God's work in the DA's office into the private sector and coming up with some recommendations for us that we can really use to sink our teeth into when we're looking at possible solutions to many of the problems. I don't have any other questions other than those comments. Thank you.
Thank you.
Jackie, thank you. Can I say one thing, though, because I want you to help us give Jackie two tools. One, Jackie needs a aggravated assault felony of the third degree statute that allows us to deal with ongoing course of conduct criminal physical abuse, as well as use of an implement such as a belt, extension cord, a boot, a hairbrush. We did not get into that at all, but it's a very important tool. We lose cases between the aggravated assault and the misdemeanor that need to be captured in a more significant way. And Jackie needs House Bill number 1264 to pass. That's going to allow her to introduce expert testimony that will help our jurors and our judges understand our children and our victims.
Yes, and you know the history of the case law behind that bill, so we appreciate that. And I guess that does bring up another point. I have been asked by many of the prosecutors that do domestic violence cases to consider the idea of bringing forth some sort of crime that, in particular in domestic violence situations where children are witnessing acts of violence on another person, but wouldn't necessarily be limited to the family setting, could be chargeable against any person who's subjecting a child to witnessing a violent act against a third party. Do you have any thoughts on that?
In handling domestic violence cases over the years, I'm in favor of a statute like that. I don't know how easy that would be to pass and what the proofs would be, but you could make it an enhancement for sentencing if a child was present, which I think is a reasonable compromise that reaches the issue that concerns us, but also allows us to implement it in a way that will work here.
Good afternoon, Gina. Good to see you again.
Great to see
Thank
you.
you. Thank you so much. If you've listened to any of it, I'm certainly a big proponent of training, and what you said hits real close to me, and I appreciate your optimism. You've always had that. You probably can never get enough good information, and good is the key word, and that comes from training. And right now we have investigators that go the whole gamut, and we talked a little bit about that earlier. And so I think that's an area that is so important. But one thing you mentioned I had not thought about was, or has been talked about much, is the tracking. And I think, again, there's information that could be invaluable to investigation in terms of crossing over law enforcement, welfare. I think the technology may give us a little break in the price tag on that, because up until now it's been manpower and woman power, and I think now there's a lot that we can do with the technology that's evolving. Spoke a little bit, Ms. Gomez, about the due process piece, about expediting abuse cases, and don't have to do it here, but I'm very interested in that, and would love to talk to you about it.
One thing I want to say is we have a law, 404B, a rule of evidence, that allows other crimes evidence, other acts evidence, even if it's an acquittal, into evidence if we can show that it fits into one of the categories of a plan, intent, lack of accident. That is a prosecutor's greatest tool, but I think the thinking and the theory behind it should also be applied in the Child Protective Services arena, to be looking more broadly at what can help us make decisions around substantiating a case or not substantiating a case. And so that is something that we can incorporate into the tracking component, because it does inform our judgment about whether something happened or if it didn't, if there's a pattern out there.
I'd be more than happy to have that conversation offline, recognizing the hour of the time, recognizing one of the due process rights is the right to a speedy trial. Expediting that process, I think, inures to everyone's favor.
Everyone. It helps
everyone.
Yeah.
Hello. I'm glad that it was a great presentation. But one of the questions that I have is about special victims, about the time frame. Sometimes it takes them 3 to 4 months to complete an interview. It's like you're put on a waiting list, just waiting to meet with them. Does that have any impact on your prosecution in going forward? Because it's so long before the child is even interviewed and the other witnesses or whatever is interviewed as well.
We do struggle with that. We have some cases where it will come in and then the detective who's assigned isn't on for another week. And then by the time they get around to it, we have seen that issue. And that's just, again, a matter of resources and coordination. And to the extent we have CACs available and we can turn these things around quickly, we should be. And perhaps we should think about that in the broader writing of this, that when there's a child of a certain age particularly, that we want to move it quicker. It is a common problem.
But I think the question is why. So why is there the delay is what I'd need to know in that situation. If it's a delay because of ineptness, inefficiencies, and that is something that could later cause me to be subject to a pre-arrest delay motion. If it's a delay because the child's not ready to talk, we have the beauty of that statute of limitations, that it means it doesn't have to happen that week. And in particular cases, in the one that I was speaking of earlier with the young woman who had been abused at age 7 and then again from 14 to 18, she finished her senior year of high school before the arrest was made in that case because she was not prepared to go through the process. And our courts, our justice system allows for there to be that pre-arrest delay where appropriate. And I think the question really becomes why the delay is there and identifying it and seeing if we can solve it, expedite it where possible.
And I just wanted to add, I think there's some trainings going on at the Department of Human Service in Philadelphia as far as cooperating and working with law enforcement, because there was information given out, of numbers and people of importance and how to collaborate and work together. So I was just wondering, were you aware of that?
Our Children's Alliance does that annually. So annually, they'll bring all of our parties together and have conversations about how we collaborate and how we best manage these investigations and share information in a timely way.
I've seen that improve over the years, especially with Commissioner Ambrose and the leadership at the District Attorney's Office. It has gotten better over the years.
Two very brief comments. I like your idea of an enhancement piece in domestic violence areas where kids are witnesses. I like it because as counsel for a domestic violence center a long time ago and as a judge, I've dealt with this issue a lot. And I know in the juvenile court context that a huge percentage of the kids that come before us have been victims of domestic abuse, not always by being hit, but by witnessing the abuse, and it has huge long-term consequences. So the idea is a good one, and I think exploring that a little bit further might be helpful. The other area is the area of unevenness of judicial awareness and education in the context of this issue. I'll just simply state that unless and until we have mandatory education for judges like we do for lawyers, it's not happening, because there's a wide variety of resources out there at a national and state level where judges can become well-educated, but it's the old saying, unless you require it, the people that need it aren't going to be there. So I'm an advocate of it. It's a tough road to hoe, and we are in the process of, in the JCJC of exploring the possibility of a specialized academy in judicial education in the delinquency and dependency area, realizing that if it's not mandatory, then let's make it attractive and get people to the table. So that's the effort.
Thank you, Judge. Doctor?
I have a comment and then a question, because something that you said, Leslie, triggered another question in my mind. The first comment I want to make, just for the record again, is that most of the CACs around the state and around the country are really set up to do co-investigations of child sexual abuse cases, and they really are not yet set up to do co-investigations of physical abuse, of severe neglect. So I just want to, a CAC model is a fabulous model, especially for child sexual abuse, but I don't think that they have advanced yet to really be like the complete answer for kind of cooperation in investigations. So, and they could become that. I don't know that they couldn't become that, but they're not there yet, is my comment.
Have in other states who have medical providers on setting and are part of the funding and the team process.
So that's just a comment. And then the question that I have is, when you started talking about, I think what you were talking about was changes really in the criminal code, right? Like, okay, so that prompted me to think about this. There are some states where there are crimes that are kind of defined as child abuse crimes, right? Pennsylvania doesn't have any crime that's called child abuse. And I wanted to know, as prosecutors, whether you know very much about that and whether you think that that kind of a crime is necessary in Pennsylvania. Does it add anything, or is it just another way of, is it just really just terminology?
To some extent, I think it's terminology. My view is myopic, so I know Pennsylvania, and I don't know the laws of other states as well. I think it's a question of, can we capture the behavior? And so what I've struggled with over the years is aggravated assault is attempts to or knowingly and intentionally commit serious bodily injury. Well, most of our parents aren't knowing or intentionally or attempting to, and so we can't often get that F1. The F2 is the deadly weapon. And most of the implements that our parents are using on our children are not deadly weapons. And so I've got no felony conduct. I've got no mandatory minimums that might guide behavior, shape behavior, if we believe that they're effective. That's a discussion for another day. And then I'm left with just a simple assault misdemeanor. So we do have endangering the welfare of a child, which is a parent or caregiver who has a duty of care, protection, or support, who knowingly violates that duty by committing a particular act. And those acts are as broad as we choose to define them. And that is some place where we can sometimes shoehorn this conduct in, but I still think there's room for an assault charge that talks about course of conduct. All of those children, Dr. Christian, that you have seen over the years, there's no broken bone. There might not be permanent whip marks, but when they come in and they are head to toe with broken skin from an extension cord, which is, in Philadelphia, probably the most common implement of discipline that is used by our parents. We can't capture those necessarily, and those are the ones that get lost in the CPSL definitions, and they're the ones that get downgraded to our misdemeanors, which are then considered not important.
The other place where this might or might not, I'd have to have somebody like look at this, is something that I think I've mentioned before, which is on occasion, prosecutors have difficulty in getting older injuries in a criminal case because you can't, you know what the laws are better than I do, but I have an understanding that I've got a battered child that I've seen, and we can't necessarily bring in many of the old injuries. And I don't know whether a child abuse crime allows for you to look at all of the different older injuries to a child to come to a diagnosis. Many courts are good about that, but there are still some courts that are really not very
And that's not
good.
statutorily prohibited. That's judicial education.
Just the judicial training pieces can pique my curiosity a little bit, but further comment, with the help of Bev Macrath, Judge Grimm is absolutely correct. Unless you can mandate it, it's very difficult to do. But one of the advantages is with the administrative law process, the appeal process, when you have such a fine leader at the Department of Public Welfare who can say, guess what? ALJs at DPW, you're going to go through this training. I'll tell you right now, in October, we're training those ALJs at DPW. So we will have a kind of a model that we can use if we're able to get the JC, or even the trial judges on board. So there are good things happening, but I do agree with Judge Grimm. It's hard.
Thank you.
Very much. I think we've concluded. And our final presenter, who was going to be on at, 12:30, I think. Thank you for your patience, Ms. Benso.